Welcome, everyone. This is the 8th session of our book club, Reasoned Argument, the Counter to Cancel Culture. Tonight, we really focus on two great men, John Adams and Thomas Jefferson. They were, as you know, friends, and then they weren't friends. They were political enemies, and then later in their life, they came back to be friends. It's really a study not only in the conflict between these two particular men, but how it is that the structure of the Constitution survived this period of time after Washington. That is the amazing thing. So, as Forrest McDonald wrote in Novus Ordo, most of the delegates, meaning to the convention, also attach reservations or conditions to their willingness to strengthen the central authority. That's going to be a major conflict between Jefferson and Adams. Some of the reservations were ideological, though doctrinaire ideologues by no means constitute a majority of those in attendance. Then he has in parentheses, fortunately for the nation, John Adams was in London and Jefferson was in Paris, meaning these two doctrinaire ideologues were not present. And yet they are the two that end up after Washington shaping the country. Critical, because at this vulnerable period of time after Washington, it's not clear what's going to happen, but we know that there is a great division going on among the different parties that are shaping up. Remember, Washington warned about the spirit of party and how it could divide the Union. So what's going to happen when we get this very strong division between the Federalists and the Anti-Federalists? Let's go forward and see. So fortunately, besides Adams and Jefferson, Washington was in the picture, Madison was in the picture, and Hamilton was in the picture. Much of it in the background, much of it not talked about. But what we're going to want to look at is the larger context of the Alien and Sedition Acts, often not talked about when those acts and the responses by Jefferson and Madison are talked about. So let's go to our think points for tonight. One, after the Washington presidency, that's what we're focusing on first. The continuing conflict with France and the Alien and Sedition Acts. Two, the Virginia and Kentucky resolutions. And three, legislatures as speech platforms in defense of federalism. So in this first section, after the Washington presidency, the continuing conflict with France is extremely important. It's more engrossing even during the Adams administration. And it's that which prompts the Alien and Sedition Acts. So in terms of context, we often hear relatively little, and in fact, apparently, much of what is said is that there was strong support for what Adams was doing in the Alien and Sedition Acts. That is debatable, as we're going to see from one of the quotes. But the point is to understand the danger that it posed for dividing the country and ending the Union. So let's summarize what's going on with France at this point. There's not only a revolution within France, France engages in a series of revolutionary wars in Europe, beginning in 1792, and it runs to 1802, and in fact, spreads beyond Europe later on. During the first series of wars, there were early wins, but then things turned badly for France. That allowed the Jacobins, the extreme radicals in the revolution, to take power and to engage in the infamous, terrible Reign of Terror in 1793 to 94. During the second set of wars, which ran from 1798 to 1802, an unknown general named Napoleon took over and was responsible for the victories, but then he decided to take over the country itself, and that ended the revolution, and it started the reign of Napoleon. but that poses its own problems. That is to say, the principles of the revolution did not die. They infected other countries of Europe where the armies of France had gone in and conquered. Back in the US, we know that Washington gave his farewell address in 1796, specifically in the month of September. But then in October, the French started targeting American merchant ships. Not long after that, Vice President Adams defeats former Secretary of State Jefferson to win the presidency. And remember, this is not by popular vote. This is by electoral vote that was chosen in each state, and that the way they chose the electors varied, but it was not really much by popular vote. So at this point, you're dealing with a provision in the Constitution that later has to be amended by the 12th Amendment because of the problems in this election, and especially in the election of 1800. That is to say, even though Jefferson and Adams ran against each other, because Jefferson got the second highest number of votes, he becomes the president, the vice president. So you've got the winner, Adams, having to deal with a vice president who's completely opposed to his program. That is the situation that is not going to work out well. So not long after Adams is president, he decides to send a group of diplomats, including John Marshall, to Paris to try and resolve the matters between the US and France at that point. Well, this is what it was known, and you've certainly looked at it in your history books, as the XYZ affair. Those letters are given to identify, at least in a secret dispatch initially, the members from this French delegation. But the key is that in the meeting, the French demanded a bribe from the US. Now, they apparently were used to doing this with other countries, but for reasons that reflect our approach to things generally, they refused the bribe and left, or at least two of the three left. And after that, we in effect go into a quasi-war from 1798 to 1800. We call it a quasi-war because there was no declaration of war. Adams considered a declaration of war, and people learned about it, but it was never actually declared. Nevertheless, that is going to bring us into the response by the Federalist administration to enact laws. We know them as the Alien and Sedition Acts. So let's look at those acts in a little bit of detail. So the first of the acts was the Naturalization Act, and it raised the residency before being naturalized from 5 to 14 years. The Jeffersonians didn't like that because many of the, probably most of the newcomers to the country were tending towards Jefferson's party. And so they looked at it as a political action to, quote, suppress the vote. 2, the president could imprison or deport aliens considered, quote, dangerous to the peace and safety of the United States. Now, that's any aliens. That's a rather broad term, but is it during war or otherwise? 3, the same could be for males over 14 of hostile nations in times of war. That provision is still in effect today. It's been amended, but essentially the idea that you can get rid of aliens from hostile states is still good law on the books. But the biggie is the Sedition Act, prosecution for speech critical of the government. Now let's look at some of the language from the 3rd and the 4th enactments. First of all, the Alien from Hostile Countries Act. Being enacted by the Senate and the House of Representatives of the United States of America and Congress assembled, that whenever there shall be a declared war between the United States and any foreign nation or government, or any invasion or predatory intrusion shall be perpetrated, attempted, or threatened against the territory of the United States, because that's what was going on in the undeclared war, by any foreign nation or government, and the President of the United States shall make public proclamation of the events, all native citizens, denizens, and subjects of the hostile nation or government, being males of the age of 14 years and upwards, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. As I said, this is still on the books, and there's good reason for it. But it was opposed as well by the Republicans because much of what they're talking about is broader than just citizens, because we had basically open borders at that point, and everyone is anxious to have more people coming to the US. They certainly didn't want people coming to the US who were likely to support them, and especially if they were from France, being excluded from the country. Okay, so let's look at the language from the Sedition Act, in particular, Section 2. I'll read most of it. That if any person shall write, print, utter, or publish, or shall cause or procure to be written, printed, uttered, or published, or shall knowingly and willingly assist in or aid in writing, printing, uttering, or publishing any false, scandalous, and malicious writing or writings against the government of the United States, or either house of the Congress of the United States, or the President of the United States, with intent to defame the said government, or either house of the said Congress, or the said President, or to bring them, or either them, into contempt, or disrepute, or to excite against them, or either of any of them, the hatred of the good people of the United States, or to stir up sedition within the United States, or to excite any unlawful combinations therein for opposing or resisting any law of the United States, or any act of the President of the United States, done in pursuance of any such law or the powers in him vested by the Constitution of the United States, etc. They're going to be subject to criminal prosecution and punishment, including jailing. That's very strong. Where did they come up with this idea? Well, there was, and I suppose still is, a seditious libel action in England. It was part of the common law. Now, this dispute also in the US involves a question of whether the federal government has, quote, common law powers. In other words, it is both an objection to the idea of suppressing speech under the First Amendment, but also to the claim that the federal government has broad powers in terms of criminal law, when it was well understood that police powers were left to the local governments, to the states. Now, certainly the federal government has always had the power to defend itself, not only against foreign attacks, but any physical attack on buildings in the United States or federal personnel when it's directed at them as federal personnel. Yes, that goes along with the notion of defending the legitimate powers of the federal government. But this is beyond that, and that's the real issue. So why would the Federalists do this? The Republicans thought, that is, the Jeffersonian Republicans thought it because they were consolidating the government. That's what their attempt was. Are they merely defending the government, or are they consolidating the government? And what's the justification? What are the circumstances in the country at this time? Well, I'm going to read a little bit from an article from the William and Mary Quarterly. And what it's addressing are several dimensions of what's going on at the time, including the notion that everybody supported the Federalists, except in the case of these two states and their resolutions. The main argument of the article is that there's a lot more opposition out there than the Federalists understood. So let's read from this article. In addition, the remonstrators, meaning those who are in other places, not just in Kentucky and Virginia, but there were local objections to the Alien and Seditions Act. These remonstrators claimed affinity with an international and universalist revolutionary transformation of the world. Now, this historian who's writing this is not making judgments in terms of political judgments. He's merely trying to reflect the reality of the situation on the ground. Celebrating the French and the rebelling Irish, they toasted, quote, the spirit of 76, may it prevail all over the world. Well, obviously, some of these people didn't understand the difference between our revolution and the French Revolution. By this time, they ought to have, because we're talking 1798. We're talking after the Reign of Terror. I don't know to what extent they were getting widespread information on the Reign of Terror, but the idea of confusing the two may be disturbing to many at the time who don't support at all the French Revolution, even though many of the Jeffersonian Republicans do. When Samuel Brown of Kentucky first described the local remonstrances to Jefferson, he's describing to Jefferson, they weren't remonstrances to Jefferson. He emphasized the international context of their fight against Federalist legislation. Republicans ought not to despair because the Irish are fighting for us and the French can never be conquered. Wow. To the extent that this is an accurate reflection of what some people thought was going on, it certainly tends towards the extreme and tends to support a foreign country, a foreign enemy, and would seem to jeopardize the Republic, the Union. But what's happening on the other side? Well, Washington is supportive of the Alien and Sedition Acts. Hamilton really isn't much engaged yet. And the reality is that there is the federal nature of the Union. We don't want, and we've never really had, a uniformity of opinion. Some of the Federalists were under the misimpression that the country completely supported what Adams was doing. Now, he did enjoy a great deal of support, certainly in New England, and especially after the XYZ affair. But how do you balance in a federal system these conflicts? Madison talks a lot about that in Federalist 10. But now Madison is in fact involved in this, we're going to see, we know. But let's then look at what other information maybe the Federalists are getting. I want to take a little clip here from Forrest McDonald's book on Hamilton that I used the last session as well. Hamilton had urged every measure of caution lest the country be divided during a war with France. Many people don't think of Hamilton as being a moderating force, but he understood the dangers when the country is divided. And certainly division of opinion is going to exist, but you have to gauge the level of that division. Continuing. At the height of the war fever, it appeared that all Americans except the most radical Southern Republicans were united in support of the government. But that illusion soon evanesced. Late in 1798, the Virginia, Kentucky legislatures adopted resolutions authored by Madison and Jefferson. He then uses the word defying, which I think is simply inappropriate. He should have said protesting. Defying assumes that the protest was illegitimate. Several of the internal security measures passed in Congress during the summer. Early in 1799, a friend of Hamilton on the scene informed him that the Virginia legislature was preparing for armed resistance to federal authority and had, toward that end, bought up 5,000 stands of arms and raise taxes for other military measures. But we don't know whether that's actually true or not. Whether it's true, it is certainly disturbing to those who hear about it. That report was buttressed by reports that Congressman John Nicholas, a dedicated Republican and fiery opponent of the war measures of 1798, had broken with the party because he was not willing to support a movement to destroy the Union. So before going on to the next section, let's just take a look briefly at some of the things that are going on during 1799 and then into 1800. We've heard that maybe Virginia is arming itself to resist the central government. But at this time, Adams has asked George Washington to come out of retirement and take over command of an army. At that point, there was no US Army. Washington insists that Hamilton be the one to organize the army, which he goes about doing. But then Adams changes his mind, apparently, and he sends a peace delegation to Paris. And in 1800, there is a peace treaty. Now, what the French got out of that was very interesting. After they signed the treaty with us, the next day, they signed a treaty with Spain that gave them Louisiana. Now, Hamilton had been very worried about the French ultimately taking from the Spanish Florida and Louisiana and being a threat. Because remember, the French had been invading other European countries. Would they invade the United States? That was a real issue. Well, Adams enters into this peace, apparently didn't know that France was going to get Louisiana the next day. And in Hamilton's view, Adams had done a very bad job in the diplomacy. And after this, the attempt to start an army was revoked. It ended, and we didn't have an army at that point. So let's go into the next session where we actually do look directly at the Virginia and Kentucky resolutions. So section 2, the Virginia and Kentucky resolutions. We're going to have our actors Spud, McDonald read them through paragraph by paragraph as to Virginia at least. And when we get to Kentucky, we're only going to take the part that might be somewhat different. In any event, let's begin.
Resolved, that the General Assembly of Virginia doth unequivocally express a firm resolution to maintain and defend the Constitution of the United States and the Constitution of this state against every aggression, either foreign or domestic, and that they will support the government of the United States in all measures warranted by the former.
Despite what was supposedly going on in some places about supporting France, there's nothing in this resolution as it begins that indicates that. In fact, it is expressing support for the United States government. This is perfectly consistent with what they know George Washington and most Americans want, the unity of the country.
That this assembly most solemnly declares a warm attachment to the Union of the States, to maintain which it pledges all its powers, and that for this end it is their duty to watch over and oppose every infraction of those principles which constitute the only basis of that Union, because a faithful observance of them can alone secure its existence and the public happiness.
Continuing its support for the country, it says quite rightly that it is up to legislatures to resist and insist on adherence to the Constitution itself. Again, consistent with Washington.
That this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact to which the states are parties, as limited by the plain sense and intention of the instrument constituting the compact, as no further valid that they are authorized by the grants enumerated in that compact, and that in case of a deliberate, palpable, and dangerous exercise of other powers, not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for arresting the progress of the evil, and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them.
So this resolution derives, at least from what Madison is writing. For Madison, there's a challenge here because the notion of compacts among the states is inconsistent with what he understood at the time of the Federalist to be the arrangement and what was in fact the arrangement, that it was no longer a compact as such. On the other hand, insofar as he apparently was thinking that it is a compact among the people of each state in their sovereign capacity, then he is referring to what they did during the ratification period. It's a very delicate situation here, and it is reflected, as I said earlier in other sessions, that in McCullough, when Marshall talks about the people of the United States, he's referring to them in their state capacities, not as one mass. And sometimes people confuse the two. Madison is doing a dance here, if you will, in terms of trying to reconcile them and putting forward the authority of the state to resist what the federal government does, at least in terms of criticism, not in terms of military force, certainly not in this document. They have the right and are duty bound to interpose for arresting the progress of the evil. What does he mean by interpose? Just keep that in mind when we talk or look at next part of the Kentucky resolution.
That the General Assembly doth also express its deep regret that a spirit has in sundry instances been manifested by the federal government to enlarge its powers by forced constructions of the constitutional charter which defines them, and that implications have appeared of a design to expound certain general phrases which, having been copied from the very limited grant of power in the former Articles of Confederation, were the less liable to be misconstrued, so as to destroy meaning and effect of the particular enumeration which necessarily explains and limits the general phrases, and so as to consolidate the states by degrees into one sovereignty, the obvious tendency and inevitable consequence of which would be to transform the present republican system of the United States into an absolute or at best mixed monarchy.
In this paragraph, they're talking about forced construction by the federal government or members of the federal government in terms of understanding their powers. It will always be the case to some extent that there will be misunderstandings between the federal and the state government, even under the best of circumstances, because when you're looking at things from either perspective, the focus will be on whatever it is that that government, federal or state, considers most important. Remember, it was Madison in Federalist 10 who said the states and the federal government should be at odds, should be in conflict. So to that extent, there's nothing wrong with what they're doing in the sense of butting heads. And that is intended by Madison, certainly in the Federalist. But when he talks about construction and having been taken from the language of the Articles of Confederation, that's way off. And Madison, and again, I'm not sure to what extent the legislature modified what Madison said or wrote, but in particular, the whole business of the Bill of Rights was given to the Congress on the basis that it didn't do anything to change the structure. And if you put back in the sense of the construction of the Articles of Confederation, what effectively you do is to turn it back to a confederation. And we'll see that a little bit more when we get to the Kentucky resolution, the whole idea of nullification that is expressed more clearly there, whereas in this, it is only a reference I've already indicated to interposition. In any event, those two issues in terms of compact and interpretation are going to continue to be a difficult point of controversy when we get into the martial court and these issues are resolved by the court itself. The statement in the last line of this paragraph about those in the Capitol attempting to create an absolute monarchy, or at least a mixed monarchy, is just, there's no basis for it, other than maybe the personality of John Adams that seemed to be pro-British and seemed to have maybe the attitude of a monarch. But the actual exercise of that power was not in that vein. Now, to say that they weren't attempting to be monarchs doesn't say that they weren't overreaching in at least the Sedition Act. And I think they were overreaching. But to the extent that your rhetoric is a little too far, the question is, who is your audience? If this audience is really attempting to persuade people in Washington, calling them monarchs is not a very good argument. On the other hand, if your intention is largely political, or firing up the other states where there may be strong anti-monarchical sentiment and having them believe that such a thing is going on, well, that's a different audience. That's a different matter.
That the General Assembly doth particularly protest against the palpable and alarming infractions of the Constitution in the two late cases of the Alien and Sedition Acts, passed in the last session of Congress, the first of which exercises a power nowhere delegated to the federal government, and which, by uniting legislative and judicial powers to those of executive, subverts the general principles of free government, as well as the particular organization and positive provisions of the federal Constitution, and the other of which acts exercises in like manner a power not delegated by the Constitution, but on the contrary, expressly and positively forbidden by one of the amendments thereto, a power which more than any other ought to produce universal alarm, because it is leveled against the right of freely examining public characters and measures, and of free communication among the people thereon, which has ever been justly deemed the only effectual guardian of every other right.
The argument about separation of powers, that the Alien and Sedition Act violates separation of powers, is difficult to understand in a way. I mean, if there was going to be a violation, it would have been simply an extension of the common law understanding of seditious libel, where you simply prosecuted without a statute and had the court recognize the common law of seditious libel. But that didn't happen here. What happened was the legislative body, Congress, enacted it. So although the statute is subject to criticism, I don't think the criticism based on separation of powers is at all valid. Beyond that, the statement, and it's reflected in the First Amendment, that's what he's talking about being expressly forbidden. Yes, there is the protection of speech and press in the First Amendment, a very important protection. He wrote it for the Congress, although it was modified as other aspects of the Bill of Rights were. But it was still unclear, really, until much of the mid part of the 20th century, the extent to which free speech was protected or press was protected. There were certain restraints. Over time, those restraints were reduced quite a bit, almost to nothing, but it's still not absolutely free, certainly in times of war. Now, again, I go back to, was this a declared war? No. Does that make a difference? I think so. Why? Because in World War II, in effect, where there was a declaration of war, the federal government did much to control speech. In later so-called wars that were not declared by Congress, there was more resistance, as indeed there should have been, when there is not a formally declared war. Back to the Second World War, those who were opposed to intervention in Europe, they quieted down once there was, in fact, a declaration of war.
that this state, having by its convention, which ratified the federal constitution, expressly declared that among other essential rights, the liberty of conscience and of the press cannot be canceled, abridged, restrained, or modified by any authority of the United States, and from its extreme anxiety to guard these rights from every possible attack of sophistry or ambition, having with other states recommended an amendment for that purpose, which amendment was in due time annexed to the Constitution. It would mark a reproachable inconsistency and criminal degeneracy if an indifference were now shewn to the most palpable violation of one of the rights thus declared and secured, and to the establishment of a precedent which may be fatal to the other.
Given Virginia's role and Madison's role in particular in the Bill of Rights, it's certainly appropriate for Virginia to be leading the protests here regarding the First Amendment.
That the good people of this Commonwealth, having ever felt and continuing to feel the most sincere affection for their brethren of the other states, the truest anxiety for establishing and perpetuating the union of all, and the most scrupulous fidelity to that Constitution, which is the pledge of mutual friendship and the instrument of mutual happiness, the General Assembly doth solemnly appeal to the like dispositions of the other states, in confidence that they will concur with this Commonwealth in declaring, as it does hereby declare, that the acts aforesaid are unconstitutional, and that the necessary and proper measures will be taken by each for cooperating with this state in maintaining the authorities, rights, and liberties referred to the states respectively or to the people.
In the penultimate paragraph, or second to last paragraph, it expresses their sincere affection for those in the other states. Indeed, that affection or friendship is absolutely necessary to maintain any political body. When friendship ceases, any political body is in danger. Now, what's really interesting to me is that down at the bottom here, he says he hopes that other states will take necessary and proper means to oppose these acts. Well, he doesn't define necessary and proper. The same language that he's criticizing in the text of the Constitution. It shows that these kinds of words are left to discretion. He's leaving it to the discretion of other states as to what is and isn't appropriate, necessary, and proper. I'm omitting the 8th paragraph, the closing paragraph, which is really just a submission paragraph with a direction that this resolution be sent to the Congress and other parties. And now turning to the Kentucky resolution, much of it's the same, or at least in the same spirit. But in the Kentucky resolution, written at least basically by Jefferson, what we have is stronger language in terms of what the state claims it can do. So I'm editing certain things out and including other things. And this particular slide is showing that other states weren't going along with Virginia and Kentucky in their opposition to what was going on. Indeed, a number of states were in fact supporting what was happening in Washington. And the contention was made, especially in New England, that it was only the obligation or the duty of the Supreme Court to say what was constitutional. The states couldn't say what was constitutional. Well, later on, New England will change its mind when, during the War of 1812, it decides that it supports a form of nullification. An essential problem from the beginning. It's one thing to be a union. It doesn't mean you have to all agree on everything, and they don't. But the question is whether Kentucky goes too far.
Least, however, the silence of this Commonwealth should be construed into an acquiescence in the doctrines and principles advanced and attempted to be maintained by the said answers, or least those of our fellow citizens throughout the Union, who so widely differ from us on those important subjects, should be deluded by the expectation that we shall be deterred from what we conceive our duty, or shrink from the principles contained in those resolutions. Therefore,
The resolution is a right, again, to express its support for the Union. The problem is the underlying premise in the argument. That is, the premise is not the same Union that is described both in the Federalist and in the text of the Constitution. What they're talking about is a compact of the states. They're talking about a form of confederation. So if the premise is different, if the two sides aren't agreeing on what the nature of the Union is, each can support the Union, but they're supporting different things. And while that gets resolved in a way at this point, nullification reemerges later on, as we well know.
Resolved, that this Commonwealth considers the Federal Union, upon the terms and for the purposes specified in the late compact, as conducive to the liberty and happiness of the several states, that it does now unequivocally declare its attachment to the Union and to that compact, agreeable to its obvious and real intention, and will be among the last to seek its dissolution. That if those who administer the general government be permitted to transgress the limits fixed by that compact, by a total disregard to the special delegations of power therein contained, annihilation of the state governments and the erection upon their ruins of a general consolidated government will be the inevitable consequence.
This paragraph starts out indicating that other states say the federal government is the judge of all of its own powers. Well, certainly to a large extent, that's going to be true when cases are litigated in the federal courts. But it's also true that in the Senate, the states are represented, or at least they were before the 17th Amendment. And they can make different judgments about that, even in the face of Supreme Court decisions. What I mean is not that they can contradict Supreme Court decisions, but as Jackson did later, the fact that the court says the bank is constitutional doesn't mean the country has to have a bank. That's a question for Congress. So again, it's the understanding, or I would say misunderstanding, of the nature of the Union that leads to a lot of problems. And when in this paragraph they talk about nullification, that is a serious problem. That is, we can't have a situation where the states separately are nullifying laws. In that case, you don't have a government. But it is, on the other hand, perfectly right to push back when the federal government does exceed its powers. And in the debate, in the conflict, that's what it's always been. It is through conflict that we resolve these kinds of issues. And the conflicts are several. They can be between the states and the federal government. They can be between the different branches of the federal government. That has been the great strength in many ways of our country and our Constitution.
That the principle and construction contended for by sundry of the state legislatures, that the general government is the exclusive judge of the extent of the powers delegated to it, stop nothing short of despotism, since the discretion of those who administer the government, and not the Constitution, would be the measure of their powers. That the several states who formed that instrument, being sovereign and independent, have the unquestionable right to judge of its infraction, and that a nullification by those sovereignties of the unauthorized acts done under color of that instrument is the rightful remedy. That this Commonwealth does, upon the most deliberate reconsideration, declare that the said alien and sedition laws are, in their opinion, palpable violations of the said Constitution, and how cheerfully it may be disposed to surrender its opinion to a majority of its sister states in matters of ordinary or doubtful policy, yet in momentous regulations like the present, which so vitally wound the best rights of the citizens, it would consider a silent acquiescence as highly criminal. That although this Commonwealth, as a party to the federal compact, will bow to the laws of the Union, yet it does at the same time declare that it will not now nor ever hereafter cease to oppose in a constitutional manner from what quarter soever offered to violate that compact.
Election of 1800 has been called often the Revolution of 1800, as if Jefferson was able to upend a lot of things. He certainly was more deferential to the states, and that was all to the good. But how much was he really able to change? Well, John Adams was able to appoint John Marshall to the court. And we know that there was a lot of conflict between Jefferson and Marshall. They had two different views of the Constitution. But the Marshall Court prevailed, and in doing so, they were simply implementing the Constitution as written and as explained in Federalist papers. And as we know, it happened that Hamilton, in the election, when it went to the House, in the contest between Burr and Jefferson, he urged his fellow Federalists to vote for Jefferson because he was incorruptible, whereas Burr, he didn't think was at all that type of good character. In any event, it shows that there were still people who were concerned about the good of the country. And that sense has prevailed for most of our history, that we've had a number of good leaders who have that sense and are not totally committed to party. I've titled this third section, Legislatures as Speech Platforms for Federalism. Now, in a way that fits with the resolutions that we've already been looking at, that is the Virginia and Kentucky resolutions. But I'm using the term speech platform in a way to link it to what is going on today. So I'll talk a little bit about speech and ultimate terms of rhetoric. That's from chapter 9 of Richard Weaver's book. But then I'll talk more about the meaning of platform and how legislatures might begin again to do what Kentucky and Virginia did many years ago, and that is adopting certain kinds of resolutions. So in terms of ultimate terms of rhetoric, the chapter in Weaver was written in the 50s. So a lot of the terms are no longer around and there are new terms. But the point of the chapter is very important, and that is somebody, somewhere, somehow sets the terms of debate. And so often, both conservatives and libertarians find themselves on the defensive because they accept, often unwittingly, the terms that are given to them. Question, is there a way to change that? And that's what we're going to be looking at. But before we do that, just compare where we started with the Declaration and then the French Revolution. So in the Declaration, what are the important terms that we went over? Human nature, creator, truce, unalienable rights. All men are created equal. Liberty. What happens in the French Declaration? We have liberty, not in context, just liberty, equality. Well, that's an abstraction from all men are created equal, but is much potentially broader. And fraternity, well, it should mean brotherhood or friendship. Friendship, something that Washington talked about in terms of the friendship of all citizens of the United States. But today, that friendship seems to be very broken. In some ways, like, but maybe even more so than at the time of the Alien and Sedition Act and the resolutions challenging those acts. So let's look at the idea of legislatures again as a social platform. Why am I saying that? Well, if you look back to the position that Jefferson and Madison found themselves in, they could not speak out themselves without risking prosecution. Well, you might think, wow, nobody would prosecute Madison and Jefferson. Well, they didn't know that because editors had been being prosecuted, editors of papers that favored their party. Well, I thought we had free speech back then. We had, after all, the First Amendment. And what about the Glorious Revolution and the English Bill of Rights? The English Bill of Rights only ensured free speech for members of Parliament. They knew then if they went through the legislature, that could not be an occasion for triggering the Sedition Act. So in a sense, They had no other platform than the legislature. Critical point, I think. Well, why didn't they just test it? Well, to test it, they would have had to have been arrested and prosecuted. What the Jeffersonians did was to avoid federal court. They didn't want a ruling on the Alien and Sedition Acts. Why? All the judges were Federalists. Why would they want a ruling? That was not a good idea. In any event, later, many years later, Justice Story in his commentaries would say that all of the judges on the Supreme Court, justices, thought the Alien and Sedition Acts were constitutional. But as he said, it was proved to be prudent not to continue them. Yes, and in fact, what that does is to reinforce the notion in Hamilton's essay number 84 in the Federalist that the real protection of political speech, of any kind of speech, is political public opinion. He was vindicated on that very point. Well, over time, the view of Madison and Jefferson takes hold, but it takes some time. So what can legislatures do today, maybe? That is, there's a lot happening in the area of federal criminal law, and there has been for a long time, something I've written on and spoken on for years. It's very difficult to get anybody's attention until they're indicted. And then when they're indicted, it's too late. Nobody else wants to pay attention to them. But what is happening now with the Justice Department sending the FBI and others to get involved in local school board election or controversies, not the elections. That is an amazing, unbelievable, unprecedented extension of even an already overbroad view of federal power. But there doesn't seem to be complaint at the national level, certainly not in the media. But what about at the local level? Yeah, there's a lot of complaint. But how do you get the local complaints to come together? Well, I suggest that it is quite possible that legislatures could decide to pass their own resolutions. There are certain advantages to this. Well, for one thing, the legislature passes a resolution, it's not subject to the governor's veto or anything like that. It's not a piece of legislation. I don't know that resolutions in any of the states can be vetoed. So there's that thing. They can't be sued. What happens when in certain states legislation is passed on something that would seem that everyone would be for? Election reform, that in a way is not partisan. But that gets sued on right away. And so the state's on the defensive. It's always better to be on the offensive than on the defensive. And if they lose, they're going to pay attorney's fees. So there's a lot of advantages to doing something that could be broad, doesn't involve the detail necessarily of a piece of legislation, not subject to veto, not subject to litigation. Of course, it'll be condemned. I understand that. But realize that in the Kentucky and the Virginia resolutions, there were only 2 states that did it. There were a total of 16 states. In other words, 1/8 of the states did it, but it had an impact. I suggest that if a number of states, if they properly drafted such a thing, could, in coordination with each other, it could have an impact. So that's a critical issue. But it would be important not to adopt the viewpoint expressed certainly in the Kentucky resolution about nullification. That's got to be off the table. And it couldn't be in terms of interposition even. It has to be simply a statement that is nonpartisan. This is affecting all kinds of people. It's got to be nonpartisan, so it's clearly directed not by party concerns, but by concerns for the common good. The other thing on platform is to talk about the other definition of platform. That is, there are two definitions. One is something to stand on. And from that term, we got the idea of political platforms. What are they? Something that parties are supposed to stand on. What are they? Their policies. It is a way of speaking to people. But parties, they're partisan, and they don't necessarily follow the spirit that Washington was so concerned about. They increase the problems, not decrease the problems in many cases, depending on how the policies are framed, how they are articulated. But think about what is going on in the whole business of the new social media. How can we relate this back to what Madison and Jefferson did? Well, what they did was not merely to object to the Alien and Sedition Acts. They laid down a set of principles or platform and policies. First of all, they made it clear that in their view, the Union was a compact among the states. Now, that is not the view that Madison took at all in the Federalist Papers, and he understood that it wasn't a compact. The way he apparently rationalized it was that it was ratification by the people, yes, in each state. That's certainly true. It was compact among the peoples in the different states, and that the legislature would be speaking for the people of the state, not as the state as sovereign. Interesting way to get around that. But in any event, there is a legitimate role for states to push back. Remember, Federalist 51. States are supposed to be in conflict against the federal government. Since the 17th Amendment, as I've said many times, that really doesn't happen. What else did they do in those resolutions? There was a principle of interpretation that was related to the compact. It related then to other things, including, you may not have realized this, an economic view. One of the reasons I gave you that chapter on political economy, if you wanted to read it, because it's pretty deep in terms of economic thought and public finance, and not everyone would want that kind of detail. But it's important at least to understand that there was a fundamental difference between Hamilton and Jefferson and Madison on the other side. And interestingly, it's stated by Forrest McDonald that until the bank issue, Hamilton and Madison didn't even realize that they didn't agree on these things. And that apparently, that realization is the moment that leads to the break between them. So an economic viewpoint was in there as well. In other words, there was a lot packed into both of those resolutions. In other words, they were operating on certain premises. Now, it's important that conservatives and libertarians not adopt the compact view. That view is simply untenable, although I know a number of conservatives talk about it that way. Any resolution that went off in that direction would be dismissed, and it should be dismissed even by knowledgeable conservatives. So what would a resolution state or do? What might legislatures talk about in terms of a resolution regarding social media? Well, first of all, they would recognize that there is a change in the economic order. And it is being largely driven by a handful of very powerful companies. And how do they do that? Interestingly, they do it through the right of contract and the right of property. And they abuse both of them. How so? Well, you know that nobody can really read all of the terms and understand them. I've read some of them and understand most of them, but not all of them. And then what happens, even if we say that you consent, if you read it, and of course you have no choice otherwise, but what about the changes that are imposed on you without your reading? What kind of contract is that one party can unilaterally change it? Why doesn't that vitiate consent? And how about the right of property? The right of property. Wait a minute. Before we consented, did anybody tell us how much money was involved? What are we giving up? What is the value of our data? What is the value that we're giving up? That would normally be part of a contract. In any event, what I'm suggesting is not a solution to this. And we know already that a number of states, as well as the Department of Justice, is filing antitrust and other suits against some of the social media companies. But it would be worth state legislatures saying, we are concerned about changes in the economy that we have no control over. And we'd like to talk about the right of property and the right of contract. And think about that, how it should or shouldn't apply in the current context. As Professor Randy Barnett says, and he has nothing to do with what I'm saying here, but I've heard him give several excellent lectures about the critical role of the right to contract and the right to property as essential for liberty. That is where our liberty is grounded. It's not like the French understanding of liberty. Ours is grounded in the rule of law. The French may have laws, but their understanding of the abstraction of liberty is not grounded in the way that the Anglo-American understanding has been grounded. Coming back then to these issues is important for us because there's a lot to think about there. The readings for next week include from Novus Ordo, chapter 8. But if you read nothing else, make sure you read pages 282 to 284. And from Professor Barnett's book, I'm moving up chapter 4 from 2 weeks hence, and at least read, and the only part you need to read for next week is pages 85 to 90. Now, in addition, I'm going to have a link to a 10-minute video from a Federalist Society production, well done, on the Louisiana Purchase itself and the constitutional crisis created by that. Now, during this period, which runs from about 1810 to 12 up to the Civil War, there are a lot of great speeches because there's so many great and threatening constitutional issues. And the speeches are long, so it's going to be a challenge for me to get shorter ones that you can read and I can have read on screen for you. So I will put those selections up on the website, that is on the event page for the book club. So thank you again for joining us, and I hope that you're able to join us next week.